Why did Taylor Swift spend 3 years re recording her music, and how does this shed a light onto how property ownership actually works? The answer to this question is actually a bit complicated, so I'm going to break this video up into 6 parts to try to keep everything in line a bit better. Okay, let's start with a bit of quick background for those of you who aren't aware. Taylor Swift is a massively successful artist whose record breaking tour, the Eras Tour, ended in December of last year. Prior to and then throughout the Eras Tour, Swift put a lot of effort into re-recording many of her old albums, releasing Fearless, Taylor's version, and Red, Taylor's version in 2021, and then Speak Now, Taylor's version, and 1989, Taylor's version in 2023. To an outsider, re-recording your already massively successful discography might seem like a weird thing to do, and in fact there are even die-hard Swifties that don't fully understand the motivations behind the re-releases. However, this decision can be explained easily by understanding the fundamentals of how property law actually works. So let's dive into it. Many non-lawyers think of property ownership as a binary system. You either own something or you don't. But it's not that simple. It is extremely common for multiple people to own different rights to the same property at the same time. The most common example of this is when you rent an apartment. Two of the property rights that a person can hold are the right to sell property and the right to occupy property. If you're a renter, you've purchased the right to occupy a piece of property for a certain period of time, which is a property right. The landlord, on the other hand, has given up the right to occupy the property, but they've retained the right to sell the property. Of course, the right to occupy isn't really what normal people mean when we say someone owns property. But from a legal perspective, a renter kind of does own property. It just happens that the right they own, the right to occupy, is one of the least valuable rights associated with the property. Property law professors often describe property rights as a bundle of sticks. Instead of thinking about property ownership as a yes or no situation, think of it as holding a bunch of sticks in your hand. If you give someone a few of your sticks, you'll still have a decent number in your hand, but now there are two people with sticks. Similarly, if you own property, you probably hold most of the rights related to the property, but you might not hold all of the rights. We've already talked about occupancy rights, but there are many other examples of different people holding different sticks. It's possible for you to own your house, but for someone else to own the right to determine how much you can sell that home for. Think of a low-income neighborhood with rent controls, or a land trust that is set up to ensure the homes remain affordable. It's also possible for you to own a house, but for someone else to own the right to modify that house. Think of an HOA that won't allow you to paint your house yellow because it'll ruin the neighborhood aesthetic. And finally, it's also possible for you to own a home, but have there be someone else who holds the right to profit from that property, meaning it's your house, but if it ever gets rented or sold, someone else is going to receive the money. This situation is common with siblings. If you inherit the family home from your parents, you will probably inherit it jointly with your siblings. And even if you're the only one living in the house, you're still going to have to split the proceeds from any sale with them. All this to say, if you tell a lawyer, I own this piece of land, a good lawyer is going to have some follow-up questions. Not because they don't believe you, but because they want to know what rights you actually have. Now, I realize this isn't intuitive. It took me a bit of time to really wrap my mind around it back when I was a first-year law student. In everyday life, we think of property ownership as a system where you either own something or you don't, but like everything else, there's more to it. So, because it's important for the rest of this video, and really for life in general, I'm going to quickly summarize the idea. When you own property, you don't own just one thing, but rather a bundle of things, which may or may not include everything associated with a given piece of property. Let's now take this idea and apply it to music. The copyright to a piece of music is considered property after all, and just like land, there are multiple rights associated with music, and different people can own different rights to the same piece of music. In the music industry, the two most important rights are called composition rights and master rights. To understand the difference between these two rights, we're going to have to engage in a bit of philosophical thinking and recognize that there's a difference between a song and a recording of a song. Imagine a burger. There are two things that are associated with the idea of a burger: the actual tangible burger that you are currently eating, and the recipe that describes how to reproduce that burger. When it comes to music, composition rights are like the recipe. The person who owns composition rights owns the underlying musical composition, the lyrics, the guitar chords, the rhythms played by the drum, in short, anything that is part of the song. In contrast, master rights are like the specific burger you are eating. They refer to one specific recording of the song rather than the song itself. The song itself is protected by composition rights, but the version of the song that you hear on Spotify is protected by the master rights. It's common practice within the music industry for the label to own the master rights and for the artist to own the composition rights. This is because, while the artist wrote the song, the label provided all the recording equipment and production knowledge necessary to record that song. Without the artist, there would be no song, but without the label, there would be no recording of the song, and so generally the rights are distributed accordingly. In addition to owning the master rights, record labels will also almost always require an artist to agree to an exclusivity clause. This is because the master rights only apply to one particular recording, not to all recordings. If the artist could go around making other recordings of the song, the master rights the label holds wouldn't be worth as much. By making sure that only one studio recording exists, the label is able to increase the value of their master rights so that they can make their money back. So, building on what we learned in the last section, ownership of property consists of multiple rights that can be and often are owned by different people. In music, the most important rights are the composition rights, the rights to the song, and the master rights, the rights to a particular recording of that song. It is extremely common for the artist to own the composition rights, while the record label owns the master rights. Record labels then also almost always require the artist to agree not to re-record the song with anyone else. Okay, so with that legal background, it's now time to pick up with Taylor Swift's story. There have been lots of headlines claiming that Taylor Swift has been fighting over the rights to her songs, but it would really be more accurate to say that she's been fighting over the master rights to her songs. She never lost control of the composition rights, the rights to the actual songs. It's clear that this is the case, not only because that's the way property law works in music, but also because she was allowed to perform her songs on the Eras Tour. If she had completely lost control of her songs, she would not have been allowed to perform any of them on the Eras Tour, as this would have been a copyright violation. It was the master rights, the rights to the specific recordings of the songs as they appeared on the original albums, that she wanted. This is the reason there were never any plans to re-record Lover or Folklore or Evermore. After her contract with Big Machine Records ended in 2017, Swift signed on with a new label, Republic Records. By 2018, Taylor Swift was a spectacularly successful artist and was able to negotiate a deal that included keeping control over both the master and the composition rights to her new songs. Taylor Swift never planned to re-record her albums that were released after 2018 because she already owned the master rights to those songs. Fast forward to 2019 when Big Machine Records decided to sell the master rights to Taylor Swift's songs to a man named Scooter Braun. Braun was famous for managing Justin Bieber, Ariana Grande, Demi Lovato, and others. I'm not going to get into it because it's outside the scope of this video, but Taylor Swift had reason to strongly dislike Scooter Braun and felt that him purchasing the master rights to her songs was not good. The issue was that there seemed to be very little Taylor Swift could do about this. People often talk about Taylor Swift's music being stolen from her, and while it's true that Big Machine Records and Scooter Braun acted immorally, from a legal perspective, nothing was stolen. Taylor Swift never owned the master rights to her songs, and something can't be stolen if it was never yours to begin with. So what could she do about it? She offered to buy the master rights, but Big Machine said no. And she couldn't sue because no one broke any laws. Well, you might be starting to see that there is a super secret third option. So let's stop and take a second to sum everything up again before we get to the decision to re-record Swift's old music. First, property rights are not an either you own it or you don't system. There are multiple rights associated with property, and different people can own different rights to the same property. 2. Music has two important rights associated with it: composition rights and master rights. Composition rights refer to the underlying musical composition, the words and the notes, while master rights refer to a particular recording of the song. And 3. When Taylor Swift was first starting out, Big Machine Records offered her a pretty standard record deal that included an exclusivity clause preventing her from re-recording her songs and allocated the rights to the songs so that Swift owned the composition rights and Big Machine owned the master rights. Here's the thing though, exclusivity clauses generally don't, and likely cannot, but that's a topic for another video, last forever. Swift's contract preventing her from exercising her composition rights and re-recording her songs had an expiration date. If she can't get the master rights to her old songs, what if she just waited for the exclusivity agreement to expire and then created new recordings of her songs that would have new master rights that she could then own? She could even then use a frankly genius marketing strategy and refer to the new songs as Taylor's version. Who knows? The new versions might even end up being more popular than the original. This is what Kelly Clarkson was suggesting in this 2019 tweet. Clarkson understood that property law is not a binary system. She understood that different rights can be owned by different people, and that, while Swift might not have the rights she wanted, she still had other rights that could prove valuable. Honestly, massive props to Clarkson for understanding the concepts that we've discussed in this video. We've all gotten used to this idea now that 4 Taylor's version albums have come out, but at the time this was truly out-of-the-box thinking. I'm not even sure fully trained lawyers would have been able to come up with this. This is really the Kobayashi Maru option. It's not the way the game was supposed to be played, but it still works, so why not do it? Without Clarkson's suggestion, we may never have gotten the Taylor's version albums and all the vault songs that came with them. So, to bring it all back to the questions that started this video, Taylor Swift re-recorded her old albums not as a way of revisiting her old music or to create an opportunity to release vault songs, but to exploit a quirk of property law, a quirk that you now are an expert in. There was no way she would ever have been able to buy the master rights to her old songs, at least not at the time. But what she could do was exercise her composition rights to create new recordings that were exactly like the original. These new recordings would have new master rights, and she could make sure that she created them with a record label that would allow her to keep these new master rights. And in that roundabout way, she'd end up with what she wanted without playing Scooter Braun's game. Alright, but so why am I talking about this? The fact that Taylor Swift re-recorded a bunch of her old albums isn't exactly news. Well, there are 3 reasons. First, I just think this is a really cool example of thinking like a lawyer. When thinking about a legal issue, we need to remember not to think of the issue as one thing, but as a series of smaller questions. The question is not just, how do I gain control of the master rights? The question is, what are master rights? How are they created? And are there any parts of the answers to the previous 2 questions that I can take advantage of? This kind of step-by-step thinking is crucial to understanding and working with the law. Second, Taylor Swift's experience with her old music is a really good example of property law concepts in action. These kinds of property law issues, property ownership being broken up into a bundle of sticks, and figuring out who owns which stick and what that entitles them to, are what property lawyers do every day. The work of a property lawyer isn't just buying or not buying something, but about determining what rights they want to buy and for what price. Which rights can you sell to other people, and which ones do you absolutely need to maintain control of? And finally, I made this video because it shows that the seemingly pedantic and academic areas of the law has real impacts on the world around us. The bundle of sticks that is property law set Taylor Swift on a path that she probably never expected, and has sent other people on similarly unexpected paths. Though these paths probably didn't include completely changing the way the music industry functions. It's important that we all understand how the law works, at least at a basic level. This not only will help us understand our world better, but also allow us to organize our lives in a more stable way. Thank you very much for watching all the way to the end. If you learned something and enjoy this kind of video, please consider subscribing. I do my best to post videos like this once a week, and subscribing is the best way to keep up with this project. If you've got time, I'd also love to hear your thoughts in the comments, including any other legal topics you'd like a future video to cover. Thanks again, and I'll see you next week.